Comps section, the law. Question 1. Explain the importance of academic freedom in higher education. Academic freedom involves a freedom to engage in the entire range of activities involved in the production of knowledge, including a research focus, determining what to teach in the classroom, presenting and publishing research findings. Academic freedom is important in higher ed as it provides a framework from which faculty members, students, and institutions can recognize the extent of the rights they can declare in the academy. According to the AAUP, American Association of University Professors, academic freedom in higher education is defined as follows. Teachers are entitled to full research freedom and the publication of results. Teachers are entitled to freedom in the classroom in discussing their subject, but should be careful not to introduce into their teaching controversial matter which has no relation to their subject. College and university teachers are citizens, members of a learned profession, and officers of an educational institution. When they speak or write as citizens, they should be free from institutional censorship or discipline, but their special position in the community imposes special obligations. Hence, they should at all times be accurate, should exercise appropriate restraint, and should show respect for the opinions of others, and should make every effort to indicate that they are not speaking for the institution. The search for truth through academic freedom requires that scholars be protected in posing new, controversial, and even unpopular ideas through their teaching and research, and publication of their research. The First Amendment, penumbral in the legal sense, is a metaphor describing implied powers of the federal government. The First Amendment penumbral rights include freedom of inquiry, freedom of thought, and freedom to teach. The First Amendment protection requires the requisite state action to be present and may provide minimal protection for faculty in private institutions. Protection of academic freedom in private institutions must come either through state constitutional protections that reach private institutions or through contract principles. Open forum. New and controversial ideas are openly discussed. The First Amendment, or freedom of speech, is most highly protected in the U.S. The AAUP is saying here that faculty members are experts in their fields and must be accurate in speaking. Negative attention brought to the university can result in termination even to tenured faculty. The First Amendment, per the courts, protects new and controversial ideas. What is taught is protected, but how it is taught is not protected. Public speech of private concern is not protected. Speech that disrupts the institution and is considered harmful is not protected. But public speech of public concern is protected. The law, question 2. What is the legal relationship of a college or university with its students? There is a wide range of legal relationships between colleges and students, instances in which students and colleges prevailed, and a chronology of the changes in the legal characterization of this relationship. The basic legal relationship between a student and a private university or college is contractual during a time of enrollment in programs that are approved by the institution. The contract between student and university is for the term for which tuition is paid. Therefore, the student and the institution can expect from each other reasonable behavior. Higher education institutions have the right to charge mandatory fees to all students if the students are treated equally, if it does not interfere with their constitutional rights or state laws. The First Amendment does not prohibit universities from requiring all of its students, regardless of religion, to pay fees for general support services. Students may not legally refuse to pay for part of such fees because they object on religious grounds to some of the services covered by the fees. Universities may be sued for breach of contract if they fail contractual obligations with students, such as Ross v. Creighton University in 1992. According to Family Education Rights and Privacy Act, or FERPA, individuals under 18 are considered adults on the college campus, and their educational records are protected. Thus, in loco parentis does no longer apply on college campuses because of the 26th Amendment. In terms of admission decisions, race cannot be a base for exclusion, but can be considered in admission process. Students do not have a right to a college education. It is a privilege. There is no due process in academic decisions. The university is not liable for students' behavior. However, it has to provide a safe environment for students' learning to occur. Universities have the right to dismiss students for academic incompetence if there is no arbitrary intent involved. Universities have the authority to determine academic performance and can determine its own policies for dismissal. The test for arbitrary and capricious dismissal is whether the dismissal is based on sufficient reasoning. It should have been sufficient reason. Question 3 in the law. Describe the various aspects or examples of de facto discrimination and explain how institutions can prevent any such infractions. De facto discrimination in higher education means discrimination in practice, but not necessarily ordained by law. It can be discrimination based on individuals' race, ethnicity, religion, gender, sexual orientation, etc. This kind of discrimination can also occur due to mental or physical disability. De facto discrimination can lead to exclusionary practices within institutions that can impact students, faculty, and staff as well. Sexual harassment in the workplace is an example of de facto discrimination. Another example can be the gender discrimination that can occur when men are rejected from admission into a predominantly female nursing program or females denied from single-sex military training. In order to prevent infractions of de facto discrimination by an institution, the higher education practitioners should implement, for example, the affirmative action policies that provide equal access to education for those groups that have been historically excluded or underrepresented, such as women and minorities. Higher education institutions need to ensure that they create policies and procedures that are consistent and equitable for all members of their community. The fourth question under the law. What are the rights and responsibilities of faculty in public institutions? In order to carry out the mission of public institutions, faculty members, as members of both the academic and the broader public community, have the right to a clear statement of academic freedom, tenure, and other fundamental faculty rights and responsibilities. Academic freedom includes the right as teachers to discuss in the classroom any material which has a significant relationship to the subject matter as defined in the approved course description. The right to determine course content, grading, and classroom procedures in the courses they teach. The right to conduct research and to engage in creative endeavors. The right to publish or present research findings and creative works. The right to engage in public service activities, and the right to seek changes in institutional policy through established university procedures and by lawful and peaceful means. Academic freedom carries with it responsibilities, including the responsibility to carry out teaching, research, and public service duties in a professional manner and in keeping with the university's policy. The faculty members have a right to expect that the university's tenure system is characterized by high integrity and a responsibility to participate in the operation of the tenure system seriously and in good faith. All decisions involving tenure system recommendations should be made in conformity to the university's approved policies and procedures that govern the tenure system. The faculty has a right and responsibility to participate in the establishment and functioning of a governance system at the department or school, college, and university levels. The faculty members, as teachers, have the responsibility to make every effort to be accurate, objective, and effective. Faculty members have a responsibility to conduct research and engage in creative activity in their areas of appointment and professional competence. As scholars, faculty members have the right and responsibility to create, seek, and state knowledge freely and openly, and to strive for scholarly excellence. Faculty members, in accordance with university policy and regulations, can serve as valuable resources and provide valuable services by working with government, industry, public organizations, and others who are off campus. Faculty members have the right to engage in a limited amount of outside work for pay in accordance with university policy and regulations.